Okay, let's unpack this. Imagine a scenario so improbable it feels lifted straight from a legal thriller. You have a high-profile individual convicted of incredibly serious crimes, serving a significant sentence. And then suddenly they're claiming that a deal made over 15 years ago should somehow magically erase it all. It sounds like something concocted for Hollywood, right?
It really does. Almost unbelievable.
But for Ghislaine Maxwell, this isn't fiction. This is her very real, high-stakes legal battle, and it's now playing out at the highest court in the land.
Welcome to the Deep Dive. This is where we take a stack of sources, articles, research, legal docs, our own notes, and really try to extract the most important nuggets of knowledge or insight, specifically tailored for you. Today, we're plunging into Ghislaine Maxwell's astonishing petition to the U.S. Supreme Court. It's an audacious bid to overturn her 2021 conviction. And this deep dive, it's all about understanding the intricate details of her immunity claim, the profound legal principles at stake. Principles that stretch far beyond this one case, actually. And, what this all could mean, not just for her, but maybe for the very future of justice in America.
Exactly.
We're going to give you a truly well-informed shortcut through this complex legal showdown.
Precisely.
Our mission today is to cut through all the noise, all the headlines, and give you a clear, concise pathway to being genuinely well-versed in this critical legal showdown. We've pulled from a range of detailed sources, including comprehensive legal analyses of very precise timelines of events, and even the actual briefing documents filed with the Supreme Court. The goal is to identify the most important insights that explain this complex, kind of multi-layered situation. We're not just defining terms here, we're dissecting the underlying arguments and, importantly, the profound implications.
Yeah, definitely going beyond the surface level. And while this story naturally has a specific individual at its center, the underlying legal principles are absolutely fascinating. I mean, really fascinating. They have far-reaching implications for everyone interested in how justice works in the United States, how federal power is structured, and like you said, how old agreements can suddenly become central to new high-stakes legal challenges. You're going to gain a much clearer understanding, I think, a new perspective on the mechanics of our highest court and the interpretation of critical legal agreements. It's truly a fascinating glimpse into the very architecture of our federal justice system. You're going to get an aha moment or two, I promise.
I think so, too. It touches on some very fundamental questions.
So let's begin with the core of the case. Ghislaine Maxwell's surprising claim for immunity. For those who, understand these types of agreements as typically localized tools, her argument for nationwide immunity stemming from an old Florida deal must seem, quite shocking, right?
It is quite unconventional, yes.
Can you lay out the background for us? Remind us about her conviction and what makes this immunity claim so unusual.
Absolutely. And it's crucial to first establish the context of Maxwell's conviction because it really underscores the gravity of what her legal team is attempting here. Back in 2021, she was found guilty on multiple federal charges. These weren't minor charges.
No.
They stemmed from her deep involvement in the grooming and sexual abuse of underage girls, essentially acting as an accomplice to Jeffrey Epstein. These were heinous crimes that, frankly, shocked the conscience of the nation.
Right. They were extensively covered.
Following that conviction, she was sentenced to a significant 20-year prison term, which she is currently serving. Now, this background is vital because her immunity claim isn't just about, say, a technicality or some procedural error in her trial.
Okay.
It's an audacious attempt to vacate a conviction for extremely serious criminal conduct based on an agreement she wasn't even a direct party to, and one that predates her conviction by over a decade. 15 years, in fact.
15 years. Wow. Okay, so she's serving this long sentence for these very serious crimes.
Yes.
And this is exactly where the complexity deepens. Because despite that conviction and sentence, Maxwell's legal team isn't arguing innocence in the traditional sense, are they? They're not challenging the evidence presented at trial, for instance.
No, not primarily in the Supreme Court petition. Their focus is elsewhere.
Right. Instead, their entire strategy revolves around this claim of immunity.
Yeah.
And it's based on this non-prosecution agreement, or NPA, from way back in 2007. What exactly is an NPA, generally speaking, and what makes this particular one so central to her current appeal?
That's precisely the fascinating part, and where Maxwell's strategy takes a really unconventional turn. So a non-prosecution agreement, an NPA, is essentially a formal understanding between a prosecutor's office and potentially a defendant or a subject of an investigation. In it, the prosecutor agrees not to pursue criminal charges.
Okay, so different from a plea bargain.
Exactly. Unlike a plea bargain where a defendant typically pleads guilty to certain charges, often lesser ones, an NPA usually aims to avoid a conviction entirely for the specified conduct. It's a strategic tool for prosecutors. Sometimes it's used when they need critical information or testimony against, say, a larger criminal enterprise.
Ah, for cooperation.
Right. Or to secure cooperation from a lower-level participant to pursue higher-level targets. They can also be used sometimes to manage resource allocation, maybe avoiding the time and expense of a full trial when cooperation can achieve the main prosecutorial goals.
Makes sense.
However, and this is key, these agreements are almost always highly circumscribed. They detail specific charges, specific timeframes, and crucially, the specific jurisdiction, the geographical area, the federal district, where the non-prosecution promise applies.
Okay, that jurisdictional limit seems really important.
It's fundamental. Now, the NPA Maxwell refers to dates back to Jeffrey Epstein's 2007 case in Florida. That was a very controversial plea deal he received down there.
I remember that, yes.
Maxwell's legal team is now arguing that this specific agreement, forged 15 years ago between Epstein and the U.S. Attorney's Office for the Southern District of Florida,
Why?
somehow extended to her as well, even though she wasn't a signatory. She didn't sign it.
Right.
And crucially, that its protective scope wasn't just limited to Florida, but was nationwide.
Nationwide, from a Florida deal.
That's their argument. It pushes the conventional understanding of these agreements to what many see as an unprecedented extreme.
So the central question, the real crux of what Maxwell's legal team is actually arguing.
Yeah.
It isn't just about the agreement itself or whether it was valid back in 2007 for Epstein.
Great.
It's fundamentally about its reach, isn't it? Its geographical reach and who it actually covered.
Precisely.
They're contending this specific Florida agreement should not be limited to that original district, the Southern District of Florida, or even just to Epstein himself, but that it should bind all U.S. attorneys across any federal district nationwide, thereby protecting her from prosecution anywhere in the country for related conduct.
Exactly. You've nailed it. Maxwell's legal team is making an exceptionally broad contention, challenging the conventional wisdom about prosecutorial agreements. They argue that the 2007 NPA, signed by a U.S. attorney in Florida, should have this sweeping authority to invalidate any future prosecution by any other U.S. attorney's office anywhere in the country for related offenses. Think about the profound implication of that. They're essentially claiming this agreement should grant her incredibly broad, almost blanket immunity, far beyond what is typically understood for such agreements.
Which are usually seen as localized, right?
Generally, yes. They're considered localized to the specific jurisdiction where they were made, and often very specific about the individual who signed it, or perhaps clearly named third parties. This interpretation is highly aggressive, quite unconventional, pushing the boundaries of legal precedent significantly.
It's almost as if they're trying to say that one agreement made in one corner of the country should have this massive ripple effect that prevents federal law enforcement from doing its job anywhere else for related matters.
That's a fair way to characterize the potential consequence of their argument, yes. It raises fundamental questions about prosecutorial independence between districts.
Wow. Okay, this isn't just about Ghislaine Maxwell anymore, is it? I mean, the implications are huge. It's about a potential redefinition of how our entire federal legal system operates.
It really is.
If her team is pushing such an expansive interpretation, they must be forcing the Supreme Court to confront a fundamental tension, a sort of clash at the very heart of our legal system.
Absolutely.
A clash between two immensely powerful, almost opposing legal philosophies or forces.
It absolutely is. This case, as highlighted in some of the detailed legal analyses we've reviewed, including a notable breakdown from legal scholars contributing to places like the Luke Court Analysis Journal, it truly represents a head-on collision, a collision of two distinct and very powerful legal forces. And understanding these forces is really key to grasping the immense complexity of what the Supreme Court is being asked to untangle here.
Okay.
This isn't a minor dispute about interpretation. It's quite foundational.
Okay, let's dive into that first force then. What exactly are we talking about when we say contract law principles in this specific context, especially when we're dealing with a government agreement like an NPA, not a typical business contract?
Right. The first force is rooted in contract law principles. At its core, contract law dictates that agreements, once validly made and agreed upon by all parties involved, are considered binding. They create enforceable obligations. Maxwell's team is essentially arguing that the 2007 NPA, despite its, controversial nature and the fact that she wasn't a direct signatory
Right.
functions as a legally binding contract or something very close to it. They assert that its terms, as they interpret them, should be honored. And not just honored for Epstein, but also extended to her and, crucially, honored universally across the entire federal system.
How do they argue she's covered if she didn't sign?
Well, they might argue various contract or quasi-contract theories, perhaps that the agreement created a unilateral contract offering immunity to a class of people, maybe including alleged co-conspirators, that she implicitly accepted. Or they might invoke the doctrine of promissory estoppel, arguing the government made a promise within that agreement, perhaps a promise not to prosecute related individuals that she reasonably relied upon to her detriment.
Okay. Complex legal arguments there.
Very much so. Now, to use a relatable analogy, and analogies are always imperfect with law, but may be helpful.
Yeah, let's try.
Imagine you lease a car in one state, say California. Your lease agreement binds you and the dealership in California for certain terms, mileage limits, service locations, etc.
Okay.
Maxwell's team is essentially arguing that her 2007 MPA isn't just a lease for a car in Florida. Instead, they claim it's like a nationwide unlimited mileage all-access pass for immunity, and that this pass somehow binds every other car dealership, meaning every other U.S. attorney's office across the entire country, preventing them from ever pursuing any related claim, no matter where new evidence emerges or different related crimes are alleged in their own jurisdictions.
That really highlights the stretch, doesn't it?
It does. It dramatically stretches the typical boundaries of how agreements, particularly those involving the government and prosecutorial discretion, are understood. Legal scholars often point out that treating a prosecutorial agreement made by one office as a perpetual, nationwide shield fundamentally misinterprets the nature of prosecutorial discretion itself.
Which is a core power of the executive branch, right?
Exactly. And it's typically seen as something that can't be easily negotiated away or constrained in such an expansive, almost accidental way by a single agreement in one district.
Okay, that helps clarify the expansive claim from Maxwell's side, rooted in this idea of a binding agreement.
Yeah.
So if contract law and the sanctity of agreements is the first force, what's the second equally powerful force that's colliding with it here? What's pushing back?
The second force, pushing directly back, is the principle of criminal jurisdiction boundaries. These are the crucial geographical and legal limits on the authority of federal prosecutors. You see, U.S. attorneys aren't like national police chiefs with unlimited power across the whole country.
Right, they're regional.
They are appointed and given authority within specific judicial districts, defined geographical areas. For example, the U.S. Attorney for the Southern District of New York, who ultimately brought the case against Maxwell, has authority within that district. And typically, an agreement they make, or an agreement made by the U.S. Attorney for the Southern District of Florida, doesn't automatically tie the hands of their counterparts in other districts. This decentralized power structure is really foundational to the federal legal system in the U.S.
Why is it structured that way? Why decentralize it?
Well, it serves several purposes. It allows U.S. attorneys to respond effectively to local crime patterns and community needs within their specific region. It lets them address specific regional priorities. And importantly, it allows them to independently pursue justice based on the evidence and laws applicable within their own purviews, without necessarily needing approval from Washington or being bound by deals made elsewhere that might not account for local facts or impact.
So independence is key.
Independence and responsiveness to the local jurisdiction, yes. Historically, an agreement made in Florida, even a formal non-prosecution agreement, wouldn't automatically prevent a prosecutor in, say, New York from pursuing charges if they uncovered new evidence related to crimes committed in New York, or if the conduct fell squarely under their specific jurisdiction, even if it involved the same individuals.
What?
This system of defined boundaries is incredibly important for maintaining order, accountability, and frankly, the efficient operation within the vast federal legal system. So a key question here becomes, can one agreement, however binding it might be considered between the original parties in Florida, can it unilaterally force other independent federal offices who operate under their own distinct mandates and responsibilities to forego their unique powers, especially when new evidence or different charges arise specifically within their purview?
That really sharpens the conflict.
It does. It raises significant concerns about the potential for one district to inadvertently, or perhaps even intentionally, hamstring legitimate justice efforts across the entire country through a single agreement.
So we have this powerful idea that a signed contract or something like it should be universally binding on one side,
Mm-hmm.
and on the other, the equally powerful established structure of geographical limits on prosecutorial authority. These two aren't just coexisting ideas here. In this Maxwell case, they are directly at odds,
Absolutely. Locked in opposition.
creating a profound legal dilemma for the nation's highest court. How in the world will the Supreme Court untangle this? What are they weighing?
Well, what's truly fascinating here and what makes this case potentially landmark is that the ultimate outcome of Ghislaine Maxwell's petition will hinge entirely on how the Supreme Court chooses to balance these two seemingly opposing forces. It's a balancing act.
Okay.
Will they prioritize the terms and the perceived binding nature of that 2007 non-prosecution agreement? Will they lean towards the contract law side, essentially giving it nationwide contractual power? Doing so could establish a precedent that drastically alters the landscape of prosecutorial discretion and interdistrict relations.
Or the alternative.
Or will they emphasize and uphold the established structural and geographical limits of a U.S. attorney's power? Will they lean towards the jurisdictional boundaries side? This would reinforce the traditional understanding that these agreements are largely localized and don't automatically override the independent authority of other federal districts to pursue their own cases based on their own investigations and evidence.
It doesn't sound like an easy either.
No, it isn't a straightforward decision that can be solved by simply reading the text of the NPA. It involves a very careful consideration of legal precedent, the historical understanding of prosecutorial discretion, the practical implications for law enforcement, and the foundational principles of federal jurisdiction. The court must weigh the idea of upholding a perceived promise made by the government, even one made 15 years ago in a different context, against the potential chaos or unintended consequences that such a broad nationwide interpretation could unleash across the federal justice system.
Right, like that form shopping concern you mentioned.
Exactly. So it raises this important question. Can a contract, even if deemed valid between the original parties, truly override established governmental structures and jurisdictional norms without potentially creating an unwieldy and unpredictable system of justice?
Whatever they decide, it sends a message.
Absolutely. The court's ruling, if they take the case, will inevitably send a very strong message about the future scope, power, and limitations of federal immunity deals.
Now that we've understood these immense legal forces at play, this clash, let's talk about the process. Where does Maxwell's petition actually stand right now in the Supreme Court's meticulous, often mysterious process? You mentioned it's at the certiorari stage. What exactly does that mean, and why is it such a high bar to clear?
Right. Maxwell's petition is currently at what's known as the certiorari stage, sometimes shortened to cert stage. This is the critical initial phase of any petition asking the U.S. Supreme Court to hear a case. And it's crucial to understand it's a very, very selective filter.
Okay, so they haven't agreed to hear it yet.
Correct. To break it down, at this point, the court has not yet decided whether it will formally hear the case. They are merely reviewing her request, the petition for a writ of certiorari, which is essentially an appeal asking them to take up her case after her appeals in the lower federal courts. Specifically, the Second Circuit Court of Appeals were unsuccessful on this immunity issue.
And lots of people ask the Supreme Court to hear their cases.
Oh, absolutely. The Supreme Court receives thousands of these petitions every single year. Literally thousands. Some terms it's over 7,000 petitions filed.
7,000, wow.
And out of that immense volume, they only choose to grant certiorari, meaning agree to hear the case through full briefing and oral arguments for a very small fraction.
How small?
Typically fewer than 80 cases in a given term, sometimes even less, around 60 or 70 recently, so maybe 1% or less of petitions are granted.
1%. That's an incredibly stringent screening process.
It really is.
So what are the 9 justices actually looking for during this initial review? It can't just be whether they think the lower court got it wrong, can it? What are their criteria, beyond just a general sense of importance?
That's a great question. No, it's definitely not just about correcting errors. The Supreme Court isn't primarily an error correction court. They are meticulously determining if the specific legal questions raised in her petition are significant enough to warrant their full attention and the use of their limited resources. The criteria are quite specific, though not rigidly defined. They are primarily looking for cases that present a compelling reason for review. One major reason is to resolve a circuit split.
A circuit split.
Yes, that's when different federal appellate courts, the circuits, have issued conflicting rulings on the same important legal question. This creates inconsistency in federal law across the country, and the Supreme Court often steps in to provide a single nationwide answer.
Okay, so uniformity is a goal.
Exactly. They also look for cases that involve a fundamental question of constitutional law that hasn't been settled, or cases where a lower court has decided an important question of federal law in a way that conflicts with Supreme Court precedent. Or, as could be argued here perhaps, a matter of exceptional public importance that impacts the functioning of the entire federal justice system, even without a direct circuit split yet.
So, in Maxwell's case, what's the argument for why her case meets these criteria?
Her team is likely arguing that the question of whether an NPA in one district can bind all other districts nationwide is a novel and exceptionally important issue of federal law concerning prosecutorial power and the interpretation of government agreements. They might argue it impacts the fundamental structure of federal prosecution and needs a definitive answer from the highest court to ensure consistency and predictability. They're essentially saying this question is too big and too important to leave unresolved or decided differently in different parts of the country. But remember, at the certiorari stage, the 9 justices are not retrying the facts of Maxwell's original conviction. They're not reviewing whether she was guilty or innocent.
Right. Purely the legal question.
Solely. They're deliberating only on whether the legal questions raised by her petition about the NPA's scope are significant enough and meet their criteria for their full attention. They typically operate under an unwritten tradition known as the Rule of 4.
The Rule of 4.
Yes. It means that if at least 4 of the 9 justices agree that a case meets their rigorous criteria for review and should be heard, they will grant certiorari. It doesn't require a majority at the stage, just 4 votes.
Interesting. Only 4.
So Maxwell's petition hinges on convincing at least 4 justices that this question of nationwide versus localized immunity for an NPA presents one of these rare, critical legal dilemmas that warrants the court's full consideration. It's about whether this novel legal interpretation could have massive systemic consequences, which is precisely the kind of structural, high-impact issue the Supreme Court often steps in to clarify.
Given that incredibly high bar, that 1% chance, what are the potential immediate outcomes of this certiorari stage for Ghislaine Maxwell? And what are the timelines we might be looking at?
Okay, so there are 2 main possibilities, and as you can imagine, their implications are vastly different for Maxwell's immediate future. First, the less common outcome, but the one her team is hoping for, the Supreme Court grants certiorari.
Meaning they agree to hear the case.
Exactly. If that happens, it would be a major development. It would signal that at least 4 justices view her arguments about the NPA scope as raising substantial legal questions that require the court's full consideration and resolution.
What happens then?
That decision would kick off a whole process. It would initiate a full briefing schedule. Both her legal team and the government, representing the prosecution, would submit extensive written arguments, called briefs, laying out their positions in detail. There might also be amicus briefs from interested third parties. This would be followed by oral arguments, where lawyers for both sides appear before the 9 justices in the courtroom to present their case and answer intense questioning.
When might that happen?
If cert is granted, say relatively soon, the briefing and oral arguments could potentially begin as early as the court's upcoming fall term, which starts in October. The whole process, from granting cert to a final decision, typically takes many months, with decisions usually issued by the end of the court's term in late June.
Okay, so that's one path. What's the other?
The second, and as we discussed, statistically much more common outcome for petitions at this stage, is that the Supreme Court declines to hear the case. They deny the petition for certiorari.
Which happens to about 99% of cases.
Roughly, yes. The vast majority of petitions are denied, often without any explanation given.
And what happens to Maxwell's conviction and sentence if the court says no? If they decline to hear her case? Does she have other options?
If the Supreme Court declines to hear Ghislaine Maxwell's case on this NPA issue, the situation becomes much clearer and, for her, effectively more final regarding the specific legal argument. Her 2021 conviction for those federal charges related to grooming and sexual abuse, and her significant 20-year prison sentence will stand exactly as they are. They won't be overturned based on this immunity claim.
So the lower court ruling holds.
Yes.
Yeah.
The decision of the Second Circuit Court of Appeals, which previously rejected her immunity argument based on the NPA, would then remain the final word on that matter within the federal court system. It essentially exhausts her primary avenue for appeal in the federal courts regarding this particular immunity claim stemming from the 2007 Florida NPA.
So she would just continue serving her sentence.
She would continue to serve her sentence without further immediate legal recourse at the Supreme Court level on this specific issue. It would effectively close this particular chapter of her legal challenges regarding the conviction itself based on the NPA. Of course, prisoners can sometimes pursue other forms of post-conviction relief on different grounds, but this specific appeal would be over.
Okay, that's clear. But let's circle back to the bigger picture. What if they do take the case? We talked about the balancing act, but what are the much broader systemic implications of either decision? Because as we've established, this really isn't just about Ghislaine Maxwell's personal legal fate, is it? The court's decision here could profoundly reshape the landscape of federal prosecution for everyone involved in the system.
You're absolutely right. The implications extend far, far beyond her personal legal fate. The Supreme Court's decision, whether they simply grant or deny certiorari, and certainly how they ultimately rule if they do hear the case, will set a critical precedent. A precedent for how federal immunity deals, particularly these non-prosecution agreements, are understood, interpreted, and enforced across the entire nation.
Okay, let's explore that first scenario again, the what if she wins scenario. Assume the court takes the case and rules in her favor. What happens then systemically?
Okay. If the Supreme Court were to rule in Maxwell's favor, fully accepting her argument that a non-prosecution agreement made in one federal district can legally shield a defendant from charges brought by prosecutors in any other federal district across the United States, well, that would establish a monumental and truly far-reaching legal precedent.
Monumental how?
It would fundamentally alter the landscape of federal immunity deals as we know them.
So, like we discussed, one local deal could effectively block prosecution nationwide for related offenses. That still sounds like it could really throw a wrench in how federal law enforcement operates.
It absolutely could, potentially dramatically. Such a ruling would drastically expand the perceived scope and enforceability of these NPAs, giving them an unprecedented, almost universal reach that they likely were never intended to have by the original parties in most cases. It would significantly limit the power and, crucially, the independence of federal prosecutors in different jurisdictions.
So.
It could make it much harder, perhaps even impossible in some situations, to bring legitimate cases against individuals who have received immunity deals elsewhere, even if those new cases involve different but related crimes uncovered later, or new evidence discovered in a completely different context or state, or impact victims in that other district.
Can you give a concrete example?
Sure. Imagine, as we touched on, a complex case involving, say, an international drug trafficking ring, or a large-scale financial fraud scheme that spans multiple states, multiple federal districts. A key defendant involved in that ring could potentially, strategically, secure an NPA in a smaller, perhaps less resourced federal district for a relatively minor related charge. Maybe they offer limited cooperation on just one tangential aspect of the conspiracy.
Okay.
If that agreement, under a pro-Maxwell ruling, then provided nationwide blanket immunity for all related conduct, it could effectively cripple the efforts of federal prosecutors in other major districts like New York or Chicago or LA, where the bulk of the criminal activity occurred or where the main evidence lies.
That's the forum shopping idea again.
Exactly. This scenario, often termed forum shopping, could allow sophisticated defendants or their lawyers to actively seek out jurisdictions perceived as potentially more lenient or maybe just less aware of the full scope of the conduct in order to gain an unprecedented shield against prosecution everywhere else. It could seriously undermine the collaborative efforts of various U.S. attorneys' offices and federal agencies like the FBI, DEA, or IRS, whose mandates are often inherently multi-jurisdictional and rely on cooperation between districts.
So it disrupts the whole system.
It could, yes. This isn't just a minor technicality. It's about setting a legal principle that could fundamentally reshape how federal cases are investigated and prosecuted. It could create profound, perhaps unintended consequences across the entire federal justice system by limiting inter-district cooperation and the ability of prosecutors to pursue independent investigations based on facts arising in their own backyards.
That's a huge potential shift in power and strategy within the justice system. A single agreement having that much leverage.
It would be a very significant shift.
What about the alternative then? If the Supreme Court rejects Maxwell's argument, either by denying cert or by hearing the case and ruling against her interpretation, what does that mean for the broader legal system?
If the Supreme Court rejects Maxwell's argument, it would provide a strong reaffirmation of the current, more traditional understanding of federal immunity deals.
The status quo, essentially.
Largely, yes, but a reaffirmed status quo, which is important. This outcome would effectively cement the principle that non-prosecution agreements, while certainly binding contracts within their specific context and between the parties involved, are typically localized to the specific district in which they are made, unless explicitly stated otherwise in exceptionally clear terms, perhaps.
So the New York prosecutors retain their power.
It would mean that prosecutors in other jurisdictions, like the Southern District of New York in Maxwell's case, would explicitly retain their authority and discretion to bring their own cases against defendants based on conduct within their district, unhindered by agreements made elsewhere that didn't clearly contemplate such a broad waiver. It would uphold the existing structure of prosecutorial authority and jurisdiction. It maintains the autonomy of different federal districts to pursue justice based on the evidence gathered and the laws applicable within their own purviews.
Preserving that decentralized structure we talked about.
Exactly. It would reinforce the idea that federal law enforcement has this decentralized yet interconnected structure where distinct offices have independent mandates and responsibilities to their own districts. One agreement from one office wouldn't inadvertently tie the hands of another office across the country unless that was the explicit negotiated intent, which seems unlikely to be the norm.
So this outcome preserves the established balance of power.
It preserves the established balance of power within the federal justice system, yes. It would confirm that MPAs are powerful tools, but generally localized ones.
Okay, this brings us back to the listener. Why should you, our listener, care deeply about the specifics of this legal battle, beyond just the sensational headlines surrounding Maxwell herself? What's the broader relevance, the application of this knowledge, for anyone interested in how our justice system actually functions day to day?
That's the crucial takeaway, I think. This case is far more than just a legal footnote concerning a single high-profile defendant. It's a direct examination of the fundamental mechanics of our justice system, particularly how the intricate web of federal power is structured, how authority is allocated, and how agreements, contracts made by the government are interpreted across different jurisdictions.
So it's about the system's plumbing.
Yeah.
Way.
In a way, yes. Understanding this case provides deep insight into how our laws handle complex multi-jurisdictional agreements, how prosecutorial power is distributed and exercised among these dozens of federal districts, and what the very definition of legal immunity truly means in practice. It's not always straightforward. It really pulls back the curtain on the intricate dance between different arms of the law contract principles versus jurisdictional boundaries, and how seemingly old, perhaps obscure, localized agreements can suddenly become absolutely central to new high-stakes legal challenges years later.
Forcing the highest court in the land to step in and clarify these foundational principles.
Precisely.
It's a genuine aha moment, like I said, about how one decades-old non-prosecution agreement signed in a specific district for a specific person could potentially rewrite the rules for future federal prosecutions across the entire country. It could affect everyone involved in the federal system, from federal agents and prosecutors trying to build complex cases, to defendants negotiating deals, and even victims seeking justice in different locations. The precision of legal language and its interpretation is truly what's being tested here, isn't it?
Indeed. It reveals the extraordinary precision required in legal drafting, especially when the government is making promises that could affect liberty or prosecution. And it shows the potential for expansive, sometimes unexpected interpretation within our legal framework that can have truly seismic effects on how the system operates.
Yeah.
It underscores that even what might seem like a technicality buried in an old document can, in the right context, challenge the very foundational architecture of our federal justice system. It's not just about the words, but their reach and consequence.
So just to quickly recap the journey we've taken today for everyone listening, we've really unpacked Ghislaine Maxwell's audacious bid for Supreme Court immunity. It's centered, crucially, on that 2007 non-prosecution agreement made with Jeffrey Epstein in Florida. We've seen the core tension at play. This profound collision between fundamental contract law principles, the idea that a deal is a deal, and the equally fundamental established structure of criminal jurisdiction boundaries for federal prosecutors.
That inherent conflict.
Exactly. A clash that the Supreme Court is now being asked to resolve. Her petition, we learned, is currently at the highly selective certiorari stage, that initial screening process.
Right, the gatekeeping stage.
Where the court determines whether to even hear the case, a decision made by just 4 justices, and the stakes couldn't be higher, really. Potential rulings that could either dramatically expand the reach of these immunity deals nationwide,
Creating a major shift.
or, alternatively, firmly reaffirm the established, more localized scope of federal immunity agreements, setting a powerful precedent for decades to come either way.
Absolutely. And this deep dive into Ghislaine Maxwell's bid for immunity, I think it really shows us how the biggest, most impactful battles in the legal world aren't always fought in a dramatic trial courtroom with juries and witnesses. Sometimes, perhaps often, they're fought over the interpretation of the fine print, buried in documents from years, even decades ago. Redefining legal power, redefining prosecutorial reach in ways that echo far, far beyond a single defendant or a single case. It really makes you wonder, doesn't it? What other seemingly minor details, what other clauses tucked away in past legal agreements, plea deals, NPAs, settlement agreements we've never even heard of, might suddenly become central to future high-profile cases, prompting our highest court to once again step in and clarify the very boundaries of justice and governmental power.
That is a truly thought-provoking question. It makes you look at legal documents and historical agreements with a whole new, maybe slightly nervous perspective on their potential future impact. Thanks for joining us on this deep dive today. Keep that curiosity burning and keep questioning.